Hopefully we will get back to in-person seminars in time. But what I will do now is just share screen so I can share the slides with you. So I'll just put those to the start. Okay, so today what we are going to talk about is whistleblowing and subject access requests. So just a quick introduction. So my name is Jack Oldroyd. I'm the partner in charge of our employment litigation services. My colleague Nils O'Donoghue is the partner in charge of our crime and regulatory team. So we're going to deal with whistleblowing first, and then move on to subject access requests. There is a link between the two in that quite often with whistleblowing claims that I would deal with, we would tend to find a subject access request made by the individual at some point prior to the claim being issued. You could link a subject access request with any claim, really, that they are quite common. So Nils is going to pick up on that after I've spoken to you about whistleblowing. So just the objectives first as to what we're going to look at. So we're going to look at who amounts to a whistleblower, look at what a qualifying protected disclosure is, know when a disclosure is protected, what claims can arise, and then some practical steps to help mitigate whistleblowing claims. We'll then move on to subject access requests. So we'll understand what an SAR is, when an employee can make a request, and how you then deal with that request, again, including some practical tips. So what is a whistleblower? You've probably heard the term used widely in a variety of different scenarios. Whistleblower is a general term, and effectively we're looking at an employee or a worker who would report certain types of wrongdoing. So that typically would be something that they've seen at work, and it's normally something that would be reported to a manager, director of a business, or someone in the HR team. I think what is sometimes misunderstood with whistleblowing claims is that within an employment law context, certainly, the whistleblowing act, if you like, has to amount to a qualifying protected disclosure. So that's what we're going to focus on in this talk. And then we're going to look at, as a whistleblower, you shouldn't be treated unfairly. So we're going to look at potential claims that could arise from making that qualifying protected disclosure, and look at the protection that individual gets from raising that disclosure. Sorry, I didn't mention at the start, if anyone's got any questions as we go through this, if you want to type those out in the questions box, we'll go through those afterwards. So looking first at what a qualifying protected disclosure is. This is set out in section 43B of the Employment Rights Act 1996. And I've highlighted there the four main elements, four key elements of that particular section. So there has to be a disclosure of information, which in the reasonable belief of the worker making that disclosure is made in the public interest and tends to show one or more of the following. So the individual, if a claim is made, for example, and that they're pursuing a whistleblowing complaint, they have to demonstrate that there has been some form of disclosure, and that in their reasonable belief, that disclosure of information was in the public interest and it tended to show one or more of the following. So there are 6 options there that individuals can choose from, if you like. When the disclosure is made, we wouldn't expect them to be using these precise words. But what would be examined by the employment tribunal is the content of the information disclosed. Does it fit within one of these criteria? And I won't go through all 6, but I tend to find that there are 3 out of the 6 that most commonly come up. So the first one is a criminal offence. Criminal offence has been committed, being committed, or likely to be committed. The second one is that a person's failed to comply with any legal obligation. And thirdly, which is the fourth on the list, health and safety concerns. Those 3, from my experience, tend to be the ones that people will, the information they disclose, they will link to those 3. Obviously, there are the other 3, but those tend to be the most common ones. So what we're going to do now is look through those highlighted sections and run through disclosure information, reasonable belief, public interest, and showing one or more of those following criteria. So to do this, I'm going to talk you through some case law. So when we're talking about disclosure information, the first case of interest is Cavendish Monroe. It's an old case, it's been around a long time, but it's still current today. And in this case, the Employment Appeals Tribunal held that for a disclosure to be protected, it must involve information and not simply voice a concern or raise an allegation. And this case provided this distinction between information and simply raising a concern. And certainly when I'm acting for a company in a whistleblowing complaint, the first thing we look at is, has there been a qualifying protected disclosure? And what I will be looking at is, has there been a disclosure of information rather than someone simply raising an allegation or voicing a concern? And what they did in this Cavendish case was they gave a hypothetical situation. So this wasn't anything to do with the case itself. It was a hypothetical situation regarding a hospital ward. So the first example there, we've got the words, which is someone saying, the wards have not been cleaned for the past 2 weeks. Yesterday, sharps were left lying around. So that would be disclosing information. We then contrast that with the following statement, which is, you are not complying with health and safety requirements. That would be an allegation of wrongdoing and not information. So that in itself would not amount to a qualifying protected disclosure because it's a mere raising of concern, raising an allegation rather than actually disclosing some facts. So that was considered further in this case of Kilrain. And what they did there was they went further and considered the Cavendish example and said, well, what happens if the individual concerned says the latter of those 2 examples, you are not complying with health and safety requirements, but does it make a difference when you take into account the context within which that's been said? So what they said in this case was, if the worker brought their manager to a hospital ward, showed them the sharps left lying around and said, you're not complying with health and safety requirements, would that amount to a protected disclosure? And in this case, they said it would. So you can see here that looking at the words used in isolation, they wouldn't amount to a qualifying protected disclosure on the Cavendish example. But the difference in Kilrain and the example they looked at was the context in that the manager was shown the sharps left lying around. So those 2 put together would actually make a qualifying protected disclosure. So it's always worth, if something is said verbally to you as a manager, or if some form of disclosure is made, not always being stuck to the words used. The context might actually make it something that is more serious. So continuing that distinction, a case of Eiger Securities looks at that distinction between disclosure information, allegation of wrongdoing. So in this particular case, a complaint was made that it was wrong for a manager to take over an employee's computer and contact her clients without identifying himself, so as to make it clear that the clients were not contacting her. And the Employment Appeals Tribunal held that if the statement had stopped there would have been simply no more than an allegation of wrongdoing. However, in this particular case, the individual went on to tell her manager what her client's thought of his behaviour, and that was the provision of new information. So those taken together did amount to a disclosure of information. And reference there to new information, when disclosures are made, it doesn't always have to be new information. It can be information that's already known, and someone would be reminding someone of that fact. So don't fall foul of thinking that any disclosure information has to be new information. It doesn't. A case here of Martin is actually something that got reported yesterday, in fact, so very, very recent. And what this case said was that confusion had grown around this distinction between disclosure information and making an allegation, and actually sought to simplify that and simply said that the requirement is that there's a statement or disclosure that has sufficient factual content and is sufficiently specific to be capable of showing one or more of those listed wrongdoings that we went through. So you can see right up to the present day, this distinction continues to be challenged in the Employment Tribunal, and no doubt will continue that way for some time to come. It's always the first thing that we would look at in a whistleblowing complaint, because the individual has to establish that there's been a disclosure of information. If we can successfully argue that there hasn't been that, then the claim falls away at that point. So that's the disclosure information aspect of the test. The next point I'd like to look at is reasonable belief that it's in the public interest. So first point is, have they disclosed information? In respect of that information, do they reasonably believe that it's in the public interest? And to do that, we look at a case of Chesterton Global. And what they did was gave the following guidance in considering the public interest test. So what we're looking at here is, did the worker subjectively believe at the time the disclosure was made that it was in the public interest? If so, was that belief objectively reasonable? The tribunal can't substitute its own view, so they need to look at the worker's view as to what they thought about that disclosure and why they felt it was in the public interest. In assessing reasonableness, the tribunal is not restricted to the reasons that were in the mind of the worker at the time. So that was interesting, because there has to be something that the individual can hang their hat on to demonstrate why they believed it was in the public interest. But what this is saying is that there could actually be things that take place afterwards that qualify the earlier statement made. Belief in the public interest need not be the predominant motive for making the disclosure, and there are no absolute rules about what is reasonable to view as being in the public interest. So what I take from this guidance is that it's very subjective. It will come down to the evidence given by the individual at the Employment Tribunal as to what they thought about that disclosure and why they felt it was in the public interest. And I think compared to the disclosure of information element, I would say this is easier for individuals to overcome. So linked with that, we're looking at reasonable belief again, but we're looking here, is there a reasonable belief about the wrongdoing? So this is looking at the actual content of the disclosure of information and whether or not there's a reasonable belief that it fits within one of those 6 categories. So just to confirm there, for a disclosure to be a qualifying disclosure, worker must have a reasonable belief that the information disclosed tends to show one of the relevant failures. So interestingly, the worker doesn't have to prove that the allegation is true, and we have to consider the worker's subjective belief. So again, very subjective, going to come down to what the individual says in evidence and what information or documentation was around at that time that gave that individual that belief. But interestingly, they don't have to prove that it's true. So what they disclose may be completely false, but if they had a reasonable belief that that had taken place, that can then amount to a protected disclosure. There's a case here of Darnton, University of Surrey, which gives some guidance on this aspect and says that it would be a qualifying disclosure if the worker reasonably but mistakenly believed that a specified malpractice is or was occurring or may occur. So again, interesting there that it could be a completely mistaken belief, but as long as they reasonably believe it, that's enough. Equally, if some malpractice was occurring which did not fall within one of the listed categories, the disclosure would still qualify if the worker reasonably believed that it did amount to malpractice falling within one of those categories. So they don't actually even have to prove that it fits within one of the categories. They just have to show that they reasonably believed that it did fall within one of those categories. However, it seems quite wide at this point, but contrast with the next guidance, which is that there must be more than unsubstantiated rumours. So the whistleblower must exercise some judgment consistent with evidence and resources available to them. So again, whenever a claim is made, we would look at what information does that individual have available to them at the time, and how have they actually formed what they say is a reasonable belief. So it is subject to challenge. And the reasonableness of the belief will depend in each case on the volume and quality of information available to the worker at the time the decision to disclose is made. So links with the previous point there, there needs to be some, I suppose, reliable information available to the individual at that time for them to form that view and make the disclosure. So that covers the test of what amounts to a qualifying protected disclosure. Now just to cover off what form that disclosure could take. So generally speaking, we're looking for something in writing or verbal. Certainly, if you were looking at it from the employee's perspective, you would want the disclosure to be in writing, because then there can be no doubt as to what was actually said. I've had cases and have cases currently where the protected disclosure is verbal. It then becomes very difficult to prove when what was said is hotly disputed. And it's then going to come down to the tribunal to determine, firstly, did this individual make this statement? And if so, was it said in the way they allege? So it becomes difficult then to establish from either side whether or not there actually has been a disclosure. There can even be situations, as in this case listed here, Aspinall, where the handing over of a video recording amounted to a disclosure. But I would typically be looking out for things that are in writing. Certainly if it's something very serious, you would expect most individuals to put it in writing, but do be aware that it can be verbal. So just because someone hasn't put it down in writing doesn't mean that it won't qualify as a protected disclosure. So having made a qualifying protected disclosure, that's the first box ticked for an individual if they establish those points. So what protection do they get? So they get the protection not to be subjected to detriment. And secondly, within dismissal situations, they have the right not to be automatically unfairly dismissed. So we'll look at those 2 points now. So firstly, in respect of detriments, so this is covered under section 47B of the Employment Rights Act 96. And this states that workers have the right not to be subjected to any detriment by any act or deliberate failure to act by his employer done on the ground that the worker made protected disclosure. So very wide-ranging in respect of detriments. I've dealt with a number of whistleblowing complaints where the alleged detriments are very wide-ranging. It's impossible to provide an exhaustive list of what those detriments could be. But we've set out here some of the typical ones that we've come across. And what's happening here is the individual will be saying, well, I've blown the whistle, so I've raised a qualifying protected disclosure, and because of that, I've been subjected to these detriments. So examples of detriments could be that someone hasn't been promoted, they haven't been awarded a pay rise when perhaps everyone else has, they've been denied training when perhaps everyone else has been given training, they've been demoted for no good reason, they've been suspended, subjected to a disciplinary sanction, or even bullied or harassed. Again, it's going to come down to evidence. So if a claim is made and it's a detriment claim, it's going to be looking at evidence from the individual. They will provide evidence on why they believe there is a link, causal link between the protected disclosure and the detriment, and the individuals who are there for the company will need to give evidence as to what the reason was for that alleged detriment. So it could be that it's denied completely that what the individual complains of took place. I have had that before, where from the company's perspective, they have no recollection of what they are even saying has happened. Alternatively, it could be that the thing they say is a detriment has happened, but it didn't take place because of that qualifying protected disclosure. So if we take, for example, a failure to promote, the company could have legitimate reasons why that individual wasn't promoted or not given a pay rise. And again, we'll come on to some practical tips at the end, but that's why it's imperative that there is a document trail, that you can evidence the actions taken against individuals. And whenever we do have a detriment claim, the test that the tribunal looks at is that they must be satisfied that the protected disclosure materially influenced the employer's detrimental treatment of the claimant. So what we're looking at here in terms of materially influences is that it's more than a trivial influence. So it's going to be a balancing act by the tribunal of evidence from the claimant on one hand and evidence from individuals from the company respondent. One thing to note with detriment claims is that there is uncapped compensation. So unlike other claims where there are statutory caps in place and you will know the maximum value of the claim, with a detriment claim that doesn't apply. So it can result in much higher awards than, say, an ordinary unfair dismissal claim. So talking of dismissal, one of the other potential claims that can arise with whistleblowing matters is automatic unfair dismissal. So what we're looking at here is section 103A of the Employment Rights Act 96. And that says that employees shall be regarded as automatically unfairly dismissed if the reason or principal reason for the dismissal is that they made a protected disclosure. So if I give you an example of a redundancy situation, company goes through a process, selects an individual for redundancy. It might have been prior to that decision having been made that, let's say a few weeks prior, a qualifying protected disclosure was made, and the individual may then try to argue that I've only been selected for redundancy because I made that protected disclosure. So again, evidence is crucial to back up the reasons taken by the company. But what we're looking at here is there's always going to be a competing reason. And quite often with automatic unfair dismissal claims, if the person has service, there'll also be an ordinary unfair dismissal claim on the back of that. So they will be saying that the reason for my redundancy, selection for redundancy, was the fact that I raised a protected disclosure. If they fail on that, they will also throw in a normal unfair dismissal claim as well. So the burden in how these cases are determined is that the employee will argue what they consider to be the real reason, i.e. the protected disclosure, and then it reverts to the employer to prove on the balance of probabilities which of the competing reasons was the principal reason. So again, the tribunal is going to have to make that determination based on the evidence given as to what was the reason. And that's why it's imperative that decisions taken by companies can be backed up with evidence. Another case here to mention, Royal Mail and Jutty. So again, a case that's been around for a while. This case established that for the purpose of determining the reason for dismissal, the tribunal only needs to be concerned with the mental processes of the person who actually made the decision to dismiss. So if you have a scenario where a protected disclosure was made to someone in another part of the business, for example, and someone completely separate who would have no way of knowing about that disclosure went ahead with a redundancy and made that individual redundant, then it's highly unlikely that an individual would be able to successfully establish the link between the protected disclosure and the decision to dismiss someone. If an employee was dismissed because they made a protected disclosure, the qualifying period required for normal unfair dismissal claims doesn't apply. So you'll no doubt be aware that individuals require 2 years service to bring what we call an ordinary unfair dismissal claim. That qualifying period doesn't apply to automatic unfair dismissals. So from day one, if the individual raises a protected disclosure and then is dismissed because of that, they can still bring a claim. Dismissal will be automatically unfair, so it doesn't matter what process you went through, how detailed it is. If the reason or principal reason for that dismissal is found to be the disclosure, it will be deemed automatically unfair. And similarly with the detriment claims, there's no cap on the amount of compensation that can be awarded. So contrast that with an ordinary unfair dismissal claim where, generally speaking, the cap is 1 year's gross income. That cap doesn't apply with an automatic unfair dismissal claim. So that covers the potential claim, the protection that individuals get, and the potential claims that could arise from making a protected disclosure. Just some practical points for me to cover before I hand over to Nils. So always good if you can have a formal whistleblowing policy. So if you can follow a procedure, it makes it all the more likely that the matter may go away at that point and not result in a claim. If you can show that you're following your policy to the letter of the law, as it were, it's less likely that those individuals are going to take the matter further. Address any concerns effectively. So the outcome may not be what the employee wants, but as long as you demonstrate that positive steps have been taken, you're showing that you're actively dealing with it, you're providing them with support, and you're taking the matter seriously, it's going to make it all the better for you if a claim is made. You can show that you've looked into the concerns, and that if you have looked into those concerns, it's less likely that you've then subjected them to a detriment at a later point. The key point I'd like you to take away from today is providing detailed reasons for any decisions that are made. So again, if we look at dismissal situations, some people may think if an individual doesn't have the 2-year service, pretty safe to dismiss. If they knew that a disclosure was made and that they are getting rid of that person to effectively shut them up, doesn't matter that they don't have the 2-year service. As we saw in the previous slide, that claim can still be brought. And if there's no reasons given, no legitimate reasons for that dismissal, it's not a big leap for the tribunal to make to find that you've dismissed that person because they raised a protected disclosure, perhaps where they were complaining about health and safety breaches, or they had concerns regarding health and safety. All of a sudden, then the individual's dismissed. It's not a massive leap to make. Contrast that with a situation where perhaps someone with less than 2 years service isn't performing very well at all, they might have made a disclosure, and it might be a qualifying protected disclosure, and therefore they get the protection. But as long as the reasons given in the dismissal are sufficient enough to show that that isn't the real reason for their dismissal, it doesn't matter that they made a protected disclosure, because it's not the reason for their dismissal. So that's why evidence is key. And in dismissal outcome letters, providing as much detail as possible that you can back up with documents makes the job at tribunal that much easier if it gets to that point. And lastly, last point I'd like to take is come and take advice. Whistleblowing claims are difficult. You've probably seen from what I've been through a lot of debate of the tests that are applied, and very complex claims to deal with. And we wouldn't expect you to be making an assessment when someone makes a disclosure, whether or not that's a protected disclosure. That's for us to do. That's for the employment tribunal to determine. But if you have access to it, come and take advice. It could help certainly in how we'd suggest you deal with the situation, and it can tee the matter up, if you like. If a claim is made, it's going to make our job of defending the claim that much easier. So that brings me an end to that part of the talk. As we said, if there's any questions, we can pick those up at the end. So I will hand over to Nils now to talk you through subject access requests.
Good morning, everybody. Hope you're well. Nice to see, nice to meet virtually with you. Anyway, as Jack says, hopefully we're in a position where we can start to run these seminars in person shortly. I'm one of two solicitors here, although a number of our departments deal with data protection to a certain extent that deals with data protection issues, and at least 2 or 3 times a week we advise clients on subject access requests. They're actually not born out of the GDPR changes that occurred in 2018. They're actually a concept that's been around since the mid-80s, actually. So a lot of what I'm discussing today isn't particularly new, but GDPR has moved things on a little, particularly in respect to the timeframes that a subject access request has to be replied to. And there tends to be 2 reasons why somebody wants to make a subject access request. The first might be that there is either an ongoing dispute or an actual employment tribunal case that's live, and an individual may believe or in fact know that there is evidence which they don't have access to, which they want to get their hands on. So Jack's obviously talked about whistleblowing in some detail. It might be, for example, that Kira, who's hosting this seminar today, Jack raised a health and safety query to her, and then myself and Kira connived to get Jack out of the company because we felt he was someone who was moaning without just cause. Jack may know that that's happened, but may not have access to the emails that me and Kira exchanged on that, and he may make a subject access request to get hold of that information to show that he blew the whistle. I have to say that tends to be the case in about 50% of the queries that we see, where individuals are genuinely or genuinely believe that there is information which can support their position. That was the whole theory behind a subject access request, that it gave people access to data that employers held on them. I have to say, however, that subject access requests do have a darker art to them. And there are a number of people out there that know the amount of time and cost that even an unmerited subject access request puts an employer to, and use it as a tactic to support either a very weak claim or no claim at all. However, as you can see from the slide, an employee does have the right to obtain personal data that is being processed by an employer. And they're entitled to be given a copy of that personal data if they request it, with what's called additional information. And that additional information, there is quite a long list of what that entails. However, the most common information that you would need to give along with the data itself would be why that data is being held and how long it's being held for. And as I say, I think there's generally 2 categories. of subject access requests: one, to cause trouble, and two, to go fishing for information that they believe is or is not there. In terms of what form a subject access request can take, surprisingly, it can be quite informal. The ICO has issued very clear guidance that it can be an email, writing, verbally, and actually quite surprisingly via social media. So the ICO is keeping pace with society in perhaps a way that other areas of the law are not. So even if a request is made fairly informally, it might be you have a Twitter page as part of your organization, and a request is made by an employee or indeed a non-employee via that channel, you've got to take it as seriously as the person who walks into HR and slaps the SAR on your HR officer's desk. It doesn't need to be made directly to a particular person. Anybody within the organization can receive a subject access request and has to act on that subject access request. I think the key point there is that although it can be made to anybody, it's important that you have a clear policy that does direct it to a person. And if that particular person doesn't get it, at least the individual within your organization who does receive the request knows where to send it, so the person with data protection expertise can deal with it. Far too often, sadly, I do see SARs not acted on because they've got stuck in someone's inbox who doesn't really know what to do with it. There is a time limit now, and this was a change that the GDPR brought in, which is that a SAR has got to be dealt with without undue delay, and in any event within 1 month of receipt of the request, as you can see on the slide. There are grounds for refusing the request. And I have to say, in the context of if you suspect whistleblowing has occurred, it's probably not in fact, it's not a good idea to refuse that request. But if the request is manifestly unfounded or excessive, then you can either seek to charge a fee or refuse to act on the request entirely. I would encourage you, however, if you ever do or are thinking about refusing a request, that you do take legal advice, because there may be consequences that flow from that. In the words of Professor Whitty, Jack, if I could have the next slide.
Certainly.
What I always advise clients to do is to go through an initial assessment as soon as you've received a subject access request, because that will help determine your plan and how you approach the request. So first of all, do you actually process the data concerning the employee? It may be that you've deleted that data some time ago, for example. Consider the scope of the request. So in whistleblowing, again, using the health and safety example that Jack raised, maybe that an employer's raised a health and safety request, a health and safety concern in the past, and that's what the request focus on. I do see employers being conservative and going beyond the scope of the request and potentially tripping themselves up by just simply disclosing all the data that they have on the employee. So it's important that you do, if you can, narrow down the request as far as possible. Consider whether you intend to respond at all. I think in 99% of cases you will be. And if you are going to respond, whether the request is such that you can actually do it within the time period specified. There are some requests that I've seen that amount to tens of documents. There was one request I saw last week that amounted to probably about 250,000 emails. That is not doable potentially within the time frame that the ICO and the GDPR would like it to be done in, which is 30 days. If you can't do it within that time frame, it's important that you flag that up immediately, and by doing this assessment initially rather than 20 days in, then you're in a better position to make sure that that's made clear to everybody involved. And then work out what your approach to finding the employee's personal data will be, which is going to involve an assessment of the scope and looking at the data that you need to pick out that you hold on that particular individual. Just going back to the decision not to respond, as I say, that should only really be in exceptional circumstances. And it's absolutely vital that if you are not going to respond, and that might be because the request, it is, for want of a better phrase, simply to cause trouble, or is so excessive that you feel you can't respond, you've got to inform the individual who's made the request, and you must be clear and confident in the principles that you've applied as to why you are refusing that request. The reason I say that is because the ICO is automatically going to expect you to respond to any subject access request, and it's only going to be in exceptional circumstances that you can refuse. And also, if I was solicitor acting for an employee who was going fishing for some data, either as an employment lawyer or otherwise, and I get a response saying we're not going to respond to your subject access request, I would be looking to go to the High Court and get an injunction to make you respond to that request. So it's vital that if you do decide, well, actually, no, for X, Y, and Z reasons, we're not going to respond, that is put down on paper and communicated to the individuals who made the request as soon as possible. So just moving along, Jack, if I may. In terms of the scope, you've got to make what's called reasonable efforts to find the information that has been requested. I have seen employers refuse on the grounds that it would be too difficult or too time consuming, in their opinion, to respond to a subject access request. And it must be particularly galling to receive a subject access request from somebody you know is just doing this to put you to time and cost. However, you are still expected to make reasonable efforts, but they don't have to be unreasonable or disproportionate, which can be quite a difficult balance to strike. And that's why you've got to work out what the scope of the request actually is. But certainly what I would be expecting employers to look at is the emails, which we mostly as employees all now have, personal email accounts, any deleted data, be it electronic or otherwise, say paper records in HR, particularly with home working, mobile phones and home computers are not exempt. If there is data on those devices, you may be required to disclose those, indeed will be required if it's requested. And any backup devices, make sure you check those. What's worse is if you do half a job, if you don't disclose all the personal data, for example, when it's requested, it makes people think, what is this organization trying to hide? So it's worse to do that as opposed to do a proper job, as time consuming and in some cases as frustrating as it may be. It's also important to remember that this is a request by a particular individual. They are sometimes, in my experience, fishing for what others have said that may not necessarily concern their personal data. And it's important that you remember when responding to a subject access request that there is privacy expectations of other individuals. So redaction is going to need to take place of information that doesn't relate to this particular person, that is personal data of others. So that's the time consuming part in my experience. In some cases, redacting potentially hundreds, if not more, documents. It's just something that sadly has to be lived with and has to be done, but it's important that it is done because what we don't want is you to respond properly to a subject access request of one individual, but breach the data protection rights of a totally innocent individual within your organization. So if we could just move on, Jack. In terms of information of others, the only time you can disclose information concerning other individuals would be if that individual has consented or it's reasonable to disclose that information without the consent of that particular individual. This actually happened to me yesterday, whereby a complaint was received by a particular client that concerned a third party. What's important is that particular client gets the consent of a third party before it discloses that information. So it's not, subject access requests are not carte blanche, simply print everything off, for example, put it in an envelope and post it off. It is sadly a bit more nuanced than that. And certainly in terms of what the response should include, copy of the personal data that you've processed on a particular employee. Most of the additional information, if you have your GDPR house in order that I discussed earlier, such as your retention guidelines, why you're processing the data. If you have a good privacy policy, that would probably cover that. But you do need to remember it's not just a case of sending the personal data. It might be that you've got to justify why you were holding that particular data, and that response should be in writing, which does cover email, which I think will be the most common form that people do respond to a subject access request. What I would say is, again, think about how you're sending the data. If we're sending it via an unsecure email without a password or not via a portal, you don't want a data breach to arise out of that. And if you are sending it by email, send it to the right person. I have seen quite large swathes of data sent to individuals simply because of a misspelling of an email, which resulted in a breach. Just think carefully about how you're sending that particular data. So we can move on, Jack. In terms of what I think and how I would try and plug those gaps, have a data protection policy so that those making the requests understand the process, and that will avoid excessive or unfounded requests. Hopefully they read it. If they do, they will know that you are not going to tolerate requests that are simply phishing for potentially thousands of documents. Set out a nominated person for who's going to deal with a request so it doesn't sit in someone's in tray. Have a process for getting it to that person to ensure that everything can run smoothly, and think about your systems of how you actually hold data. 30 days is actually not a lot of time to get together what might be quite a lot of data if it's held securely and electronically, and we can do it not necessarily the push of a button, but not much more. That is a much easier place than scrambling around 4 different offices for paper copies in a locked cabinet, for example. So that is how you can hopefully get ahead of the 30-day period. And just to move on, because I've only got a couple more minutes, Jack, if I may. What I always do here, because we do get, as you can imagine, a lot of subject access requests here, and me and a colleague called Nicholas are the individuals that deal with them, is we have a simple checklist that enables us to run the process smoothly. So most access requests are going to elicit the same response initially. So if you had a standard precedent that you can send out to that particular individual, acknowledging the request or explaining why it's not going to be dealt with within the 30 days, that's a 10-second job as opposed to drafting a letter each time. Make sure we know who does what. IT are probably going to be involved in assessing the data, getting hold of it, perhaps even putting it in a format that's acceptable to send. So it's important they know what an access request is, and indeed that all your staff are aware of subject access requests. For instance, it may be that staff are sending emails with personal data of othering that might be poking fun at Jack, for instance. If they are sending that, they shouldn't be, because if Jack makes an access request, they're going to be embarrassed about the content of those emails. I'm not suggesting anyone does that within Chadwick Lawrence, by the way, Jack. But it's important that staff are aware that emails are no longer some private bastion. They can be viewed, and it might be particularly embarrassing later down the line. And if we have an initial assessment process of how to deal with the request, hopefully again things can run smoothly. A process for finding the data, and then precedents that flow off the back of that, responding to a request, then you're in a very good position. I think you should also have internal guidelines that specify sort of service standards for how we're going to respond to a subject access request. And finally, you may want access to a solicitor on tap. Do we redact certain parts of it? You may have questions on, do we send this? Do we send that? Are we able to refuse? Are we able to be in a position where we don't respond at all? Those are key questions that you may just want to run past a solicitor, which anyone within Chadwick Lawrence would be happy to direct you to. I have run over my time there, so apologies for that. If you have any questions on either the whistleblowing element or the subject access request, if you could let us know. I think Jack will probably hang around anyway if people don't want to make those questions public. But if anyone does have any questions, please do let us know.
Yeah, thanks, Nils. I think we've got a couple of questions in the chat box. Just to, I'll just stop the share screen there. Just to pick up, follow up on point there in terms of documents and in particular emails. I quite often have claims where there has been a subject access request and the individual who's brought the claim is still not convinced that everything's been disclosed. And they can still make a specific disclosure application in the employment tribunal. And I think the point to note is that a lot of people will think that internal emails, for example, are private and not disclosable, but they are. And all too often I find internal emails in companies where what's said perhaps isn't fatal to a claim, but doesn't come across the best. And particularly with a whistleblowing complaint, when you're looking at reasons for certain decisions and actions, if you've got an email where someone's criticizing someone for raising health and safety concerns, again, it's a point in the individual's favor to demonstrate that link from the disclosure to the action taken. So I think just be mindful of what is said in internal correspondence, because it is something that the individual is entitled to get their hands on. So I'm just going to look at the chats. So we've just got reference to the slides. I don't think actually then we've got any other questions. If anyone has any queries, if you could just type those in the chat box now. If not, I think we will end the talk. Question there from Andy. Thank you. Is the meeting recording going to be made available to download? Honest answer, I'm not sure, Andy. I don't know if my colleague Kira, who's on the call as well, knows whether we would do that. Kira, is that something we'd do?
Yeah, Jack, I'm going to upload it onto our YouTube page, so I'll circulate the link.
Right, fine. Okay, thanks for that, Kira. I'm just looking down. Maria, do you have any recommended internal guidelines that can be issued? So I think in respect of everything that we've talked about, I think in terms of guidelines and things like that, that's certainly something that we can pick up with you on an individual basis. If you've got any particular needs, we can obviously have a chat about that and talk through what we can provide for you. I think that's the best way of dealing with that, if that's okay, Maria. Just looking to, okay, thank you, thanks, Maria. Yeah, okay. Well, hopefully that's been of some help. It is a tricky area, I think, particularly from the whistleblowing aspect. I think people think of that term whistleblowing generically. I saw it on the news last night, the Facebook employee who's blown the whistle. I think within an employment context, it sometimes gets lost as to exactly what the requirements are. And like I said, I'm not expecting you guys to make that assessment when a disclosure is made, but if a claim is made, you're aware of the rules, and it's going to make all our jobs a lot easier if we all understand what that individual has to show. Yeah, good to get an insight from Nils on subject access requests, which again hopefully will provide some assistance. So yeah, thank you everyone for attending. I'll hold on for a couple of minutes if anyone's got any other questions, but if anyone doesn't, then please feel free to leave the chat. So thank you again for your time, and we'll see you soon.